So some basic considerations to take into account as you're crafting an arbitration agreement or commencing an arbitration, and you'll cover off all of these in much more detail in subsequent modules, but I just wanted to cover off a few of the types of choices that you will need to make either at the time of drafting your contract or commencing your dispute. So as you're crafting your arbitration agreement, which is usually done in the main contract, it's possible also for there to be a submission agreement after a dispute already arises. But as you might imagine, once the parties are already in dispute, the chance of agreeing to resolve that dispute through arbitration, or for that matter, agreeing on pretty much anything, is significantly reduced. So one main choice is, are you going for institutional arbitration or ad hoc arbitration? As you might tell from the names, institutional arbitration means that there's an institution that's established that administers the arbitration. They don't conduct the arbitration, but they administer some of the background services connected to the arbitration. So they hold deposits on behalf of the arbitrators, they assist with correspondence, they assist with the interactions between the tribunal and the parties. They also assist in the appointment and challenges to arbitrators, arranging sometimes for hearing facilities, that type of thing. But the actual determination of the dispute is by the arbitral tribunal, and that is the 1 or 3 arbitrators that are either selected by the parties or appointed by the institution. Ad hoc arbitration is different. There is no institution standing behind the arbitrators. The parties simply choose the arbitrators, and the arbitrators make their determination and reach a result. The ad hoc arbitrations are usually conducted under the UNCITRAL arbitration rules, and that's by far the preferred approach. It is possible that they can be completely ad hoc. Simply refer, for example, to the arbitration law of a particular jurisdiction, or refer to nothing. That is not desirable. You really do want to have, the rules are there for a reason. The reason the rules are there is that they have been developed to assist the parties and the tribunal in arranging and carrying out the mechanics and the procedures of the arbitration. If you're left to create everything from scratch, de novo, it's very complicated and it just takes more time and winds up being considerably more expensive. Another consideration that will come into play both with respect to the initial arbitration agreement in the contract and also with respect to how you formulate your case if and when a dispute arises are the interacting laws that may be relevant. So usually the parties will have selected a substantive law to govern the contract. That may or may not be the same law that governs the arbitration agreement. The arbitration agreement is severable from the main contract. It's a contract within the contract. And so it may be that the law of the arbitration agreement is in fact the law of the seat, which is different from the substantive law of the contract. It's important to specify these things as clearly as you can in your agreement. We currently have a situation where we're assisting a client with an arbitration agreement that specified the rules of a particular institution and a seat where that institution was located, but the substantive law of the contract was in another country. And so it came down to a question for the tribunal to determine whether the law governing the arbitration agreement was that of the substantive law of the contract or the law of the seat. And under the substantive law of the contract, there was an argument that the arbitration agreement was invalid. Under the law of the seat, there was an argument that the arbitration agreement was valid. So this conflict between which law applied, which seat was relevant, became the object of more than a year of litigation, of dispute, and considerable legal fees. So the more clarity you can include in the underlying contract up front, the better it will be, and the more that you can avoid that type of dispute. There will also be potential mandatory laws. So it may be that in a particular jurisdiction, a company organized in that jurisdiction cannot excuse itself from the application of certain, for example, consumer protection legislation. So you have to be aware of what mandatory laws may exist. There may be other relevant foreign laws, depending on the nature of the transaction and the nature of the parties. There may be international practice and soft law considerations. For example, the CISG may have implication in certain types of contexts. And you may have to also consider the law of the place of enforcement, because that also, if, for example, you have an arbitral award that includes a determination of damages and a calculation of interest as part of that damage award, if you take that decision into a jurisdiction where interest is not legally recognized as a concept, that may be problematic. You may want to split that out into two separate portions of the award. Or there was an instance many years ago where under the arbitral award awarded costs of the arbitration to one of the parties, and that was refused enforcement in a particular jurisdiction because under the rules of that jurisdiction, you couldn't allocate costs. So you need to think about those types of considerations as you're making your arguments and as you're presenting your case to the tribunal. We've mentioned the seat of the arbitration. You're going to cover this off in considerably more detail when you get to the sections on drafting the arbitration clause, but just be aware that the seat of the arbitration is the legal home in which the arbitration sits, sometimes called the place or the legal place, but it's better to use the word seat because then you're very clear. If you use place, there might be an argument that really that was just hearings, whereas seat is the legal home. There are three important consequences of that seat determination. The law of the seat will govern the arbitral process. The courts of the seat have supervisory jurisdiction over the arbitration, so things like challenges to arbitrators, interim measures, applications to set aside awards. And it also determines the nationality of the award, which is relevant for enforcement. So what are you looking for in a seat? It's not, when I was a young transactional lawyer, the counterparty would sometimes say, well, let's have Malta as a seat because it's nice and warm. Well, nice and warm, a good vacation destination, that's not a good reason for choosing a seat. Good shopping is not a good reason for choosing a seat. What you want in your seat is an arbitration-friendly jurisdiction that has very strong courts that are very pro-arbitration with a strong history of adherence to the rule of law. So any of the major seats around the world fit that category, but placing your arbitration in less known jurisdictions may bring questions. So just as an example, if your seat is in London, the arbitration is governed by the English Arbitration Act 1996. The supervisory jurisdiction over the arbitration is that of the English courts. Now, the seat does not necessarily mean the place of the physical hearings. You can have a seat in, say, London, but have your venue be in Jakarta if the parties don't want to travel. Or you can have your seat in Singapore, but your venue in Paris. Seat is what you choose based on who you want, which courts you want to have supervisory jurisdiction, venue you choose on convenience, where it would be most convenient for the parties to actually physically meet to hold the arbitration. And it may very well be in the current times that your venue is virtual because no one is traveling to hearings at the moment, or many people are not traveling to hearings at the moment, and they're simply having virtual hearings. All of the popular seats are in neutral venues, as I mentioned, with a strong rule of law and support of arbitration by the judiciary. And finally, and this is something that comes only once you've commenced a dispute, you're going to have a choice around selecting an arbitrator. Now, some parties put some of these qualifications in the arbitration clause up front. Just a word of warning that that can be dangerous because it can significantly narrow the options available to you in your arbitrator selection, and you may not want to narrow those options until you know what your dispute is actually about. So in one example that crossed my desk, we had a situation where the arbitrator needed to be on the CTAC panel, that's the Chinese Arbitration Institution, needed to be not a national of Hong Kong, which included China and Hong Kong, or a national of the EU, which at the time included the UK, had to be fluent in Mandarin and English, and had to be Hong Kong qualified. In the end, as we looked through the list, there were 5 people that met those qualifications. 1 had been appointed by the other side. 3 had conflicts, which meant that there was 1 person left to choose. So when you're looking at these questions, it's really best in your arbitration agreement to keep them as broad as possible. And then when you're selecting the arbitrator, you can look at things like commercial and cultural know-how, language skills, procedural preferences, legal expertise, availability, and the compatibility of the person you're considering with the other arbitrators that have been chosen by the other parties. So that concludes our whistle-stop tour of Introduction to Arbitration, and I hope that you found that useful and interesting. If you do have questions that arose from this session, I welcome you to reach out. My email is there on the screen, and I would be more than happy to attempt to address them. Thank you very much, and thank you for listening.